Hi guys, how are you doing? Welcome back to True Crime After Dark. Hopefully you guys can hear me okay, and thank you to Rick's Wars for helping me get my mic figured out so you guys can actually hear me. Let me know in the comments if it sounds better. So this is an important video. It's got some evidence of a motion. This is the second one now that was filed that we found that has been uncovered that shows that the defense filed motions to the state trying to get some evidence about people and about the autopsies. And they were denied this until Chris took his plea. So that's a problem, big problem. And she does a really good job of explaining it. So it's by Unapologetically Me. And let's get into the video. Before we do, please leave a like and subscribe to our channel. We are truth seekers, and that's what we're looking to do, is get to the bottom of this. So let's get into the video without further ado.
Buried in the paperwork of the Chris Watts case is a motion that almost no one has talked about. It wasn't about guilt or innocence. It wasn't about evidence we already knew. It was about people, witnesses that the prosecution claimed hadn't been interviewed yet. And according to Chris Watts' defense, the DA was desperate to keep these witnesses a secret. Why? Well, once you hear who these witnesses may have been, you might start asking some even more uncomfortable questions, as if we haven't asked enough already. Hello, everyone. Welcome back to UMTC. How are you all doing today? I hope you're having a great day, week, weekend. I hope you're ready for some new information on the Watts case. Please like, share, comment, and if you really like these videos and you're learning something from them, please feel free to subscribe. It is a free way to support the channel. Thank you to all my subscribers and my members. You can always check out my community page for any updates, so I don't use up anyone's valuable time explaining things during these videos. I am just going to start just going over to the community page to talk about anything that I don't want to waste time with in the videos. So let's get into this court document that is seemingly innocuous, yet is anything but, at least in my opinion. In the Chris Watts case, there was a motion filed that most people have never even heard of. One that hints there may have been witnesses who have not yet been interviewed. Who were they? And why did DA Michael Rourke fight so hard to keep them a secret? This is
Okay, this is the motion. I want to read a little bit of it to you. It says Mr. Watts filed today a motion in case number 18CV30907 to intervene in the proceeding pursuant to Colorado Rule of Criminal Procedure 24. As of the filing of this motion, the court there, the Honorable Todd Taylor, has yet to rule on Mr. Watts' pleading. Out of an abundance of caution, Mr. Watts files this motion before the court, as well if the court denies Mr. Watts' motion in case number. Mr. Watts respectfully moves this court to hold a hearing on whether the release of the autopsies could result in tainting witnesses that have not yet been interviewed. Witnesses, guys. That's not one, that's two or more. And Nicole Kessinger was interrogated. So who are these other witnesses? I think I have a feeling, but anyway, let's continue. However, counsel for Mr. Watts remains concerned about the government's spurious claims related to the tainting witnesses who have yet to be interviewed. Counsel remains specifically concerned that the government possesses information that the defense does not have. Big problem. It is not clear if the government's assertion means that it has knowledge the witnesses may change their testimony once they see the coroner's opinion. It is not clear which witnesses the government knows about who have not been interviewed that may have a reaction to the opinion of the coroner. It is not clear what information the government possesses that would lead them to such a conclusion. This is a giant problem, guys. I want to show you. I went over to our good buddy ChatGTP, And I asked, in the state of Colorado, if a man enters a plea agreement and later finds the evidence was withheld, what would this mean for Colorado law? I did this because some of you in the comments like to argue back and forth whether this can happen or not, and it can. Sure, okay? It says short version. In Colorado, if someone takes a plea deal and later discovers that prosecutors or police withheld important evidence, it can potentially blow up the plea. But it's not automatic. It usually becomes a Brady due process issue raised through a post conviction motion, and a court has to decide how serious the violation is and what the remedy should be. So, the basic rule: the state must disclose expulsionary evidence. What that can mean after a plea. If later the defendant discovers that police or prosecutors had evidence that would have helped him, and the evidence that was not disclosed before he entered the plea, and if it's material important enough that it could have changed his decision to plead guilty. And I think autopsy findings and this violation here is enough to have maybe had him decide that he wanted to maybe take it to trial, because there's other witnesses that weren't even asked questions. All right, let's continue.
This is a copy of a motion that was filed by Chris Watt's defense team on October 19th, 2018. This motion was filed as a backup request to another motion that was filed by Chris's defense team.
Yes, this is the second motion for this exact same thing, and both of them, as far as I know, were denied and never happened up until he pled.
This motion was a backup motion in case their main motion, which was to intervene in civil case number 18 CV 30907, was denied. This civil case was to publicize the autopsy reports. In simple terms, Chris Watt's defense was fighting to make the autopsy reports public. If the courts denied that request, they wanted a hearing held, a public one, where the DA would have to explain their reasoning for keeping those autopsy reports sealed. Many people still believe to this day that Chris Watts was the one who had these autopsy reports sealed. The fact is, he did no such thing. The fact is, his defense team tried to fight this and filed a few motions specifically about the autopsies, and this video is about one of those motions. There has also been opposing speculation that it was the Rusiks that filed for the autopsies to be sealed.
Just to be clear, autopsy has now been publicly released, but only portions of it. Most of it is redacted and left out.
This comes from those who believe that they are hiding something, they being the Rusiks. But it was the DA who wanted those reports sealed. Likely, in my opinion, under the guise that he was protecting the victims and their families. Yet, Chris Watts and his defense team were never allowed to see those reports either. That is against the constitutional rights of the defendant, Chris Watts. So why all the secrecy? There are obvious reasons that the prosecution might have resisted releasing the autopsy reports. The first reason would be protecting the victim's privacy and dignity. I mean, we all know autopsy reports contain graphic medical details about the victims, often including photos and diagrams. Prosecutors can argue that releasing these details to the public could be unnecessarily traumatic to the victims' families, especially in a high-profile case where the media will report every single line. In this case, Shanann was also pregnant, and the children were very young. It goes without saying that the contents would be extremely sensitive. The second reason would be to prevent public misinterpretation. I smirk when I say this because it happens all the time. Every single case, every single thing that comes out of a person's mouth these days can be misinterpreted. You certainly don't want autopsy findings being misinterpreted. Autopsy findings can be very technical, and they're easily misunderstood without medical expertise. In cases with huge media coverage, small details can be taken out of context, fueling speculation or conspiracies. Prosecutors might worry that this could make it harder to find unbiased jurors during an active case or cause public backlash.
I don't think there was a chance in hell that he would find someone that wasn't biased across the whole America. I mean, this case went national. Everyone knows about it from different countries even. But this is scary because no wonder Chris Watts is sitting behind prison saying, I'm going to be getting out soon. I shouldn't be here anymore. And we're hearing all this from behind bars because they totally messed this whole case up. And with the right attorney, he could get the judge to give him a trial. And I don't think he's going to go anywhere. I think he's still going to receive life for what he did. But that could potentially bring other people into the mix. And we could potentially get our answers we've been looking for. Let's pray that that does happen. All right, let's continue.
The third reason would be preserving the integrity of the case and investigation. Even though Chris Watts pleaded guilty very quickly, there was still a period before sentencing when evidence management mattered. Prosecutors sometimes keep autopsies sealed until after all proceedings, including sentencing and appeals, are complete, to avoid influencing potential witnesses or affecting ongoing investigations. For example, if they were still looking into whether or not anyone else was involved. And the fourth reason being complying with the state law. Now, in Colorado, autopsy reports are generally public record, unless the court seals them for a specific reason, such as privacy or interference with an active investigation. If the DA wanted these sealed, they would have to show good cause. And that is what Chris Watts' defense team were challenging in this motion. Why would Chris's defense team have to fight and force the court to hold a hearing on why the DA claimed that releasing the autopsy reports could taint witnesses? Because that is the reason the defense was given for the lack of transparency in regards to these autopsy reports. Not to protect the victims or the families, but because the information listed within the reports, quote, could result in tainting witnesses who have yet to be interviewed, unquote. It was also stated that the other reason for not releasing the reports was, quote, that the results of the autopsies will taint potential jurors, unquote. Chris Watts' defense argued that claim to be, quote, groundless because the results would assuredly be revealed within the court well in advance of a trial.
Knowing we don't have a trial here, they allowed him to plea out without this evidence and denied the motion. There is the constitutional rights violation right there.
Unquote. So let's break that down. Let's unpack that. What the DA was basically saying is that if the public, including witnesses or potential jurors, sees the detailed autopsy findings before trial, it could influence what they remember, how they interpret the case, or even what they claim to know. Specifically, the DA's reasoning was to prevent witness contamination and jury bias. Now, this is extremely interesting in the Watts case. Unusual, even, because Chris Watts was arrested August 15th and he signed a plea deal November 6th. The DA's stated concern, quote unquote, potential jurors, usually applies when you expect a full jury trial. But in this case, there would be no trial. That would seem that either they didn't know there would be no trial when they filed this civil request to keep the autopsies private, or they still wanted to limit public access for reasons beyond jury concerns, such as protecting the families and avoiding public speculation, though that was never stated as a concern in the civil document that was filed. So, what does this motion reveal? The DA's public reason, according to court documents, is that releasing the autopsy reports could bias potential jurors and taint witness statements. So the defense had a rebuttal, and that rebuttal was, juror bias is a weak argument. Autopsy details are going to come out in court anyway. The real issue was the DA's claim about witnesses who hadn't yet been interviewed, suggesting the prosecution knew about people whose stories could change after seeing the coroner's findings. They suspected the DA had information they were not sharing with the defense. Why is this important? Well, first of all, it's illegal. It's against Chris's constitutional rights.
Yes.
To not even be shown the autopsy report and to not know information that the prosecution has against him. If the DA had information they were not sharing with the defense, this means that there were people out there with potential critical knowledge about the murders, and or the DA didn't want the defense team exposed to certain evidence yet, or at least didn't want their existence widely known.
Why do you think that they would have the defense lawyers would have allowed Chris to plea once these motions were denied and they didn't have all the evidence they needed? It makes me wonder. It's very shady because a lot of you have said that one of his main lawyers went to work for District Attorney Rourke after this. Sounds like maybe some backdoor dealings were going on there or something, but corrupt as hell, guys.
Another thing this motion reveals is the coroner's role in keeping the autopsies sealed. You mean all this time there was another person who was cool with hiding evidence? Not just DA Michael Rourke, but the coroner for Weld County as well. I can't remember his name, but I will put it in here as an edit. Now, we learned this from this document. We learned it from the following statements contained within this motion. According to the petition filed, you know, that 18 CV 30907 motion filed just prior to this one, the coroner, whose office is ostensibly independent from the DA's office, quote, concurs with the DA's reasoning, unquote, and has, quote, no reason to doubt the DA, unquote. It goes on to say, and try not to laugh because none of this is funny, but you know, they put these little digs into these court documents, and DA Rourke put one into the autopsy file, and it's almost like here's a rebuttal from Chris's defense, but it says, quote, counsel of Chris Watts cannot share the coroner's apparent confidence. The coroner's naked deference to the government has therefore made clear that he has no interest in challenging the government's judgment.
Why should the defense have to? They have every right to that evidence, and failing to do so, failing to make sure everyone was questioned, failing to make sure that all ends were dealt with. I mean, there was no dead ends left. And before he took this plea, they messed up big time. And something that's going to come back to bite him in the butt. I really think so.
Consequently, he has no interest in investigating and ferreting out the validity of its claim. Mr. Watts does. Now it goes on to say, the respondents to the action may have some interest in determining the validity of the government's witness claim, but their interest can, of course, be no greater than that of Mr. Watts. Mr. Watts is constitutionally entitled to know and meaningfully challenge the evidence and witnesses against him, and to have and make use of any and all information related to their veracity or credibility. Because of the government's claim that the release of the autopsies may taint witnesses who have not been interviewed, seems to suggest that there are witnesses that the government knows who may slant or change their testimony based on the autopsy results. Mr. Watts has an obvious and substantial interest in developing the record on that claim. In addition, because that result, if true, has a direct effect on the criminal proceedings in this case, this court, should the court deny Mr. Watts' request to intervene, must hold a hearing in this case. So basically, if the judge denies the defense the opportunity to have this information, then there needs to be a hearing, a public hearing, where the DA has to explain why. Why are we not sharing this information with you? Why are we doing this? Now, here's where it gets even more interesting. Even more concerning, though, the coroner requested the court allow him to offer specifics about his agreement with the DA, quote, under sealed to the court in a closed hearing, unquote. Now, what this means is the coroner's office sided with the DA and even offered to explain their agreement behind closed doors, meaning Chris Watts and his defense would never even know what was said. If the court were to allow this extraordinary request, Mr. Watts would be denied the opportunity not only to challenge the evidence, but also, and obviously more egregiously, to even know what the evidence is. Now, this is the defense arguing that this secrecy violated Chris Watts' right to a fair trial. Oh, the irony and hypocrisy. I mean, it just can't be made up. And this is where I get into it in the comments with some people. Here,
Make it make sense. How do they go from not hearing a motion, denying the motion and not giving him a hearing to him being satisfied with just pleading guilty? How do we get there? Make it make sense. I don't understand.
in the US of A, all individuals are entitled to due process. Withholding evidence and failing to prove a person guilty beyond a reasonable doubt in this country is illegal. Whether or not a person comes forward and claims to have committed a crime, it is still the prosecution's burden to prove it. Getting someone to sign a plea bargain waives that right of the accused. And I've been wanting to talk about this on its own, but there was never even a preliminary hearing on this case. You may also know it as a probable cause hearing. This is where the state has to list off all the evidence that shows cause as to why they are confident in charging someone with a crime.
Once I know what the official charges are that are filed by the district attorney's office, I'll inform you of the nature of the charges. If charges are filed, you have the right to a jury trial, and you have the right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that you committed any of the charges that are filed by the district attorney's office. Do you understand that? Yes, sir. You also have the right to demand and receive a preliminary hearing within a reasonable time to determine whether probable cause exists to believe that the offenses charged were committed by you. Do you understand?
Chris Watts never had one of these. This usually happens pretty quickly, yet there were other motions filed by Chris Watts' defense, and one of those stated that as of August 29th, 2 weeks after Chris Watts was charged with the murders, he had still not received a single page of discovery. Yet the court unsealed the affidavit on August 21st, and the media was already reporting on it, stating that the information was coming directly from sources close to the case and law enforcement. Now let's bring it back, let's reel it back in here, and bring it back to the motion at hand. The witnesses that have not yet been interviewed, that may or may not be tainted by the evidence contained in these autopsy reports. Who could these witnesses be? In theory, of course, because this can only be speculation, this first theory is my opinion, which is backed by connections that I have recently uncovered and shown to you in Part 3, Episodes 1 and 2. This would be Nicole Kessinger's inner circle, her friends, family, co-workers, and certain contacts in her phone records who were not interviewed yet and never would be. We also have to think about neighbors on Saratoga Trail, people who saw vehicles or suspicious activity, but they didn't speak on record immediately or formally. Connections to the mysterious older model gray Ford truck with a camper shell, matching a Ford Ranger owned by a William Biscay at the time of the crimes.
There you go, guys. Also, that solves that red truck issue. That was not William Biscay's red truck in the previous video. So he had this truck with the camper on it, this silver one. And the red truck, I still don't know exactly who it belongs to.
Nicole Kessinger had phone calls with this man, whom she used to work for years prior. She had conversations with him before and after the crimes. And of course, I cannot leave out the Russian concussion, Gino Shvedov, Mr. Rear Naked Chokehold himself. Now this is a connection that potentially leads back to high school. Both Nikki and Gino were the same age, they went to the same high school, they grew up on the same street, and they also both used their home addresses on that same street to start businesses.
He did it.
Gino, a sober living home, and Nicole Kessinger, a yoga studio, which she dissolved shortly after the murders. We haven't gotten into that just yet though, but we will. Now Gino was out on parole at the time of these murders. And he
Go
is the
figure.
self-proclaimed owner of Hazelbrook Sober Living and a non-profit organization called Paradigm One in Aurora, Colorado.
What do you know? There's that word again. Paradigm, 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 paradigm. Nicole used that word so many times in her police interview, and just, I think even with her and Chris when they were hanging out in one of them videos. So that's a word that she used a lot. And here we are with the paradigm word again.
Paradigm One is the recipient of government funding from Denver's cashforcaring.org. Because of his sober living transitional homes, Gino has deep links to the Department of Corrections and parole officers, as well as access to communities where information can spread quickly and where witnesses could emerge unexpectedly. And last but not least, there could be uninterviewed first responders who hadn't given formal statements yet, or civil case participants as potential witnesses. People attached to the public records battle over these autopsy reports who might overlap with the criminal case against Chris Watts as well. Now, allow me to ask the big question. If these witnesses had information that could affect this case, why weren't they interviewed right away? Was the DA protecting the trial, the victims, the families? Or was he protecting the narrative?
The narrative.
His narrative. What was DA Michael Rourke trying so desperately to hide? He wanted Chris Watts for all 4 of these murders. What?
He also wanted Chris Watts to plea out before election time. And he also was just handing off pleas left and right. Here you go. Plea for you, plea for you, plea for you. No investigation here, no investigation here. Pleas all around.
Could the autopsies possibly show that would make his narrative fall apart? One would think that the autopsies would prove, or at the very least not disprove, that all the evidence pointed to Chris Watts committing these crimes. So why keep them, even from the defense team and Chris Watts himself? I'm asking you. I know what I think. I have my opinions. I'm asking you, what do you think? My opinion? Chris Watts' attorneys were pushing back hard on the DA's secrecy. They were suggesting there might be undisclosed witnesses or information that could help the defense, and that the DA was using the quote-unquote witness tainting excuse to keep it hidden. They are subtly hinting that there could be more to the case than what is public, or at least there are more people with information relevant to the case that had not been interviewed yet. Chris Watts and his team were basically denied information and evidence, leaving them unable to challenge any of it. And worse still, they were denied even the knowledge of what any of the information or evidence was. Now, no matter what, Christopher Watts had constitutional rights to 1, know the evidence against him, 2, test the credibility of witnesses, and 3, to get a fair proceeding, which is the right to a fair trial. Without these 3 things, Christopher Watts' rights would be violated. This filing wasn't just about autopsy reports. Chris Watts' attorneys were using the fight over disclosure to probe whether there were witnesses of information they hadn't been given, which could in turn open the doors to other evidence or even weaken the prosecution's case. They were also making a constitutional argument by saying, you can't secretly give evidence to a judge and keep it from the defense if that evidence could affect the outcome of the case. And that was with regard to the coroner and DA having that private little hearing with the judge about why they really wanted to steal the autopsies. It all sounds a little shady if you ask me. The lies we have been told by the DA are not forgotten. He has deliberately misled the public on multiple occasions, and in my opinion, he personally hampered the CBI and FBI's investigation into this case. It's a disgrace to the people in the state of Colorado to know that if a violent crime takes place in Weld County, the DA will not pursue justice. He will pursue a plea deal before ever even looking into any evidence, in my opinion, allegedly, and no one, it seems, will challenge his opinion. Because if this motion filed by Chris Watts' defense team on October 19th, 2018 was granted, And there was a public hearing where the DA was forced to publicly disclose why he really wanted those autopsy records sealed and name those, quote, not yet interviewed witnesses, unquote, we might have a very different understanding of what happened in Frederick, Colorado on August 13th, 2018. That's it for today's video. Thank you so much for watching. Don't forget to give this video a thumbs up if you enjoyed.
Okay, that is the end of the video. Tell me what you guys think. Do you think this is why Chris took his plea and to start with? Because maybe he was promised something when DA comes in, he knew that his rights were violated. Is this why he's making noise from prison? Think he knows now, or knew before? You guys tell me. I wanted to remake the video with the better audio for you guys. So, all right, good night. We'll see you in the next one. Bye.